start? Yes. Being aggrieved by this judgment and order, the present appeal has been filed. The learned counsel appearing for the appellant submitted that the premises belonged to Union of India and were being managed by the appellant administratively under the Public Premises Act. Section 4 of that Act permitted a notice of 7 days, which had been given in the instant case. Even the lease document also provided for a termination of the lease by a notice of 7 days, and in any case the action was being taken after the expiry of the lease period. The lease had not been extended. That being so, the respondent was in unauthorized occupation within the definition of unauthorized occupation under Section 2G of the Public Premises Act. He relied upon a number of decisions to contend that the position of a lessee holding on under unregistered deed, which is compulsorily registrable, and a mere demand for possession is sufficient to determine the lease, and no notice under Section 106 of the Transfer of Property Act was necessary. Mr. Ravindra Singh, learned counsel for the respondent, however, lastly submitted that the respondent was owner of the premises, and secondly, the Public Premises Act did not apply to these premises, also for the reason that the cantonment boards have come to be covered under the Public Premises Act only by Amendment Act of 1993, which came into force on 7/1/1994. That is how Clause 6 governing any cantonment board constituted under the Cantonment Act 1924 has come to be included in the definition of public premises under Section 2E of the Public Premises Act. He therefore submitted that at the time when the proceedings were initiated and the order was passed under the Public Premises Act, the estate officer did not have jurisdiction to proceed under this act, and therefore for this reason alone the eviction proceedings will have to be held as bad in law for want of jurisdiction, and the appeal will have to be dismissed. He submitted that this was an issue with respect to having jurisdiction to deal with the subject matter, and the submission can be raised at any stage of proceedings. We have considered the submission of both the counsel. As for the first submission of Mr. Singh that the premises belong to the respondent is concerned, the same has never been raised any time before. On the record of the present civil appeal, we have the objection filed by the respondent before the estate officer and a copy of the writ petition filed by the respondent. Nowhere they have claimed that they own the premises. On the contrary, in paragraph 3 of their objections before the estate officer, they have stated that the executive officer of the cantonment board is the secretary and the custodian of the property. In paragraph 4 of the writ petition, they have clearly stated that the hospital building initially belonged to the East India Company and later on had belonged to the Government of India. Stop.